Good morning viewers. Welcome to the 8th webinar of our weekend webinar series on Companies Act 2013, Enable, Evaluate and Excel. Today's session is on board meetings, law, practice and procedures, Secretarial Standard 1. In this session, we will broadly cover law, practice and procedures relating to board and committee meetings, art of conducting meetings as per Secretarial Standards 1. Today's session is by CSGP Madan, founder and partner Madan Law Offices. Mr. Madan is a commerce graduate, law graduate, fellow member of ICSI, besides holding diplomas in labor laws and corporate laws and management, has vast practical experience of over 30 years in corporate legal, secretarial, capital markets, financial and managerial disciplines. He has been chairman of Institute of Company Secretaries of India, Northern Region in 2005. Since 2012, he has been co-chairman of National Council for Mergers and Acquisitions of SOCHM. Besides being member of various councils and boards, he is SOCHM's nominee on Secretarial Standard Board of ICSI since 2012. He has written various articles on different subjects for professional magazines and web portals. He has addressed many conferences and seminars organized by various professional bodies, industry associations, chambers, ministries, universities, management institutions and regulators. Now I request Mr. Madan to start the session.
Thank you, Anamika. Good morning, friends, and welcome to this webinar on board meetings, law, practice and procedures with relation to Secretarial Standard 1. Though as Anamika just mentioned that I have been nominee of SOCHM on Secretarial Standards Board since 2012. But today I am here before all of you not as a representative of Secretarial Standards Board, and whatever I am going to discuss today, that's all based on my own reading and interpretation of law, means Companies Act, rules thereunder, and the Secretarial Standard 1 on board meetings. None of the views expressed by me today should be construed as views of Secretarial Standard Board or of ICSI. With this disclaimer, I now start the proceedings of this webinar. Friends, as all of you or most of you might have experienced, that before erstwhile Company Law Board, the complaints or petitions relating to operation and mismanagement under section 397 and 398 of Companies Act 1956, and now the complaints and petitions before National Company Law Tribunal NCLT under section 241 and 242 of Companies Act 2013 are mainly pertaining to various allegations by the minority against the majority, and these allegations are normally pertaining to minority says that my majority has increased the paid up capital of the company. Some new shares have been allotted. The majority has transferred the shares in their own favor or in favor of their own associates and relatives. Some new bank account has been opened, or the signatories in the bank account have been changed. The financial accounts have been approved without the consent of the minority shareholders. Or various other allegations are made or complaints are made by the minority or against the majority, like either it may pertain to the director has been removed without his consent, new auditors have been appointed, auditors have been replaced, new project has been launched by the majority without the consent of the minority, the funds of the company have been diverted or have been siphoned off or have been invested by the majority in some other project, and all these allegations or complaints are made by the minority against the majority. And after the complaint, the prayer which is made by the minority before the erstwhile CLB and now NCLTR, that all these decisions should be declared as null and void and illegal. Why so? Then the minority says why this decision should be declared null and void or illegal is that all these decisions should have been taken by the board either at a meeting of the board of directors or at a general meeting of the members. And now the minority says that no such board meeting was held or no such general meeting was held. And even if the board meeting or general meeting was held, the minutes of the board meeting or general meeting have not been recorded properly. The board meeting or the general meeting was not convened properly. Hence, they challenge the validity of the board meeting as well as the general meeting. And then the prayer is that if the board meeting at which the decision have been taken, if that meeting is not valid, it means the decision taken at that meeting should also not be valid, and hence they should be declared null and void and illegal. Hence, in every petition, rather I'll say that most of the petition, ultimately the complaint boils down to the legality or illegality of the board meeting and general meeting. So that is why, keeping this in mind, the number of piling up cases before CLB that time and now NCLT, the government thought that let there be specific provisions relating to holding and convening and conducting a board meeting, general meeting in the Companies Act itself. Therefore, Section 118 subsection 10 was introduced by Companies Act 2013. This subsection says that all the companies shall observe the secretarial standards with relation to board meetings and general meetings. Which standards? The standards as specified by the Institute of Company Secretaries of India and approved as such by the Ministry of Corporate Affairs. Hence, it means by virtue of this section, now the standards have to be specified by ICSI, then those standards have to be approved by the Ministry of Corporate Affairs. Once this provision was notified, the Institute of Company Secretaries of India already had a secretarial standard board in existence since 2001. And that standard already came out with 10 different standards. And a couple of these standards were on book, standard on board meetings, standard on general meeting. There was one more standard on circular resolution, one standard was on proxy, one standard was on minutes. So all these standard and guidance notes were there. Now the section 118 subsection 10 combined all these things and set the secretarial standard with relation to board meetings and general meetings. Now, keeping this particular provision in mind, the secretarial standard board now set again on those erstwhile recommended standards and upgraded them on the basis of the new law, the Companies Act 2013, and the rules made thereunder. Once these standards were prepared, then these standards were thrown open to the public for their comments and feedback and suggestions. Once those comments, feedbacks and suggestions came, after that Secretarial Standard Board considered each and every suggestion and feedback from the stakeholders. And after incorporating those comments and suggestions in the Secretarial Standards, these draft Secretarial Standards were sent to the Council of the Institute for its approval. Once the Council of the Institute gave its approval, then these standards were referred to the Ministry of Corporate Affairs. Then the Ministry of Corporate Affairs again gave certain suggestions. Those suggestions were again placed before SSB. Then SSB, on the basis of that, incorporated certain changes in those draft standards. Then the draft standards were again upgraded, sent to the Council. Then Council again approved it, and after that the standard again went to the Ministry. And in the month of April 2015, Ministry of Corporate Affairs accorded its consent to the secretarial standards on board meetings as well as general meetings. Once this approval came, then the Institute came out with a notification, and Institute notified that these two secretarial standards shall be applicable to all the board meetings and general meetings, in respect of which the notice shall be issued on or after 1st July 2015. So for all practical purposes, these two standards now have become mandatory for all the board meetings conducted on or after 1st July 2015. As on date, Secretarial Standard 1, Secretarial Standard 2, the board on board meeting and general meeting is applicable to all the companies, barring certain exceptions. Those exceptions are that in the year 2015, as all of you know, the government came out with 4 different exemption notifications, giving certain exemptions to government companies, to private companies, and to Section 8 companies, and to Nidhis also. In those exemption notifications also, then we had Companies Amendment Act 2015, By virtue of these exemption notification in Companies Amendment Act 2015, certain exemptions were given to private companies as well as to Section 8 companies from the provisions of compliance of provisions of sectoral standards. So those exemptions have already been provided for. Even the preface to the sectoral standards says that whenever there is any amendment post promulgation of the sectoral standards, if there is any amendment by the government in any law or any rules or the act, and if there is any inconsistency between the act and the standards, then whatever is contained in the act and law, that shall prevail. Now after this, all this background, now I switch over to my presentation on Secretarial Standards 1, the procedure, law related to holding, convening and conducting of board meetings. Friends, this presentation I have divided into, rather is in the form of posers. Most of this presentation is in the form of posers. I'll be raising the question here and then I'll be discussing the answer to this poser, and answer whatever is here is as per my understanding and my reading of Companies Act, the rules and Secretarial Standard 1. This is, friends, the composition of Secretarial Standard Board. As on date, we have nominees from all big companies, we have practicing professionals, we have council members, then we have nominees from CII, SOCHM, FICCI, MCA, SEBI, Bombay Stock Exchange, Institute of Chartered Accountants, Institute of Cost Accountants, National Stock Exchange. So it's comprised of approximately 35 members as on date, and people and stakeholders from all walks of life of the corporate sector are members of Secretarial Standard Board, and whatever decisions are taken at SSB is taken on the basis in the absolutely perfect democratic manner. The views of all the stakeholders are taken into account, and then only the Secretarial Standard Board finalizes the standards. However, I'm again giving a disclaimer that I'm not here today as representative of Secretarial Standard Board. I'm here in the I'm one amongst you only today. The first poser which I am raising before you, what I have decided, friends, that I will be having my presentation say up to 12:30 or so, and after that at least half an hour I will be devoting for question answer session. In the meantime, if you have any question, to please raise your question, send it to the link given before you, and all those questions shall come to me. If there are multiple questions, I will be answering only one question. If there is no multiplicity, I will endeavor to give answers to all the questions which are raised. The first poser is that who may convene a meeting of the board. Though the Act is silent on this, however, the schedule table F in Schedule 1 talks about this, who may convene a meeting of the board, and SS1 also talks about this, who may convene a meeting of the board. As per SS1, any director of a company may convene or may summon a meeting of the board. However, a director may also send a requisition to the company through its company secretary and ask the company secretary to convene a meeting of the board. In that case, as per the Secretarial Standard, the company secretary shall consult the chairman, MD or a whole-time director, as the case may be, of the company, and ask him that he has received a requisition from a particular director, and director has sent a requisition to convene a meeting of the board. If the chairman, MD or WTD, as the case may be, is in agreement, okay, the board meeting is to be called, he will direct the company secretary to call a meeting of the board, issue a notice for the meeting of the board. However, the chairman, MD or WTD is not in agreement with the director making a requisition, then the company secretary shall be advised not to hold the board meeting and communicate the decision of the chairman, MD or WTD, as the case may be, to the director concerned. Then the company secretary in writing shall communicate the decision of the chairman, MD or WTD to the director concerned. However, in that case also, that particular director who sent a requisition to the company secretary has full authority, full discretion. It's his option to convene a meeting of the board. So he himself can summon a meeting of the board and he himself can issue a notice for the meeting of the board. Now, whatever, friends, the standards we are discussing today, this one, though primarily it's on board meetings, but this particular standard is mutatis mutandis applicable to all the statutory committee meetings of the company also. So I'll not be specifically referring to the committee meetings. So wherever it's conveniently possible, as I said, that mutatis mutandis is applicable to all the committee meetings also. Now the next poser is whether the meetings are to be serially numbered. If yes, why and how? The standard provides an answer to this. Standard says yes, the meetings are required to be serially numbered. And why so? Because of the reference and cross-reference at a future date. If somebody wants to check which decision was taken at which meeting, and if all the meetings are serially numbered, then it's convenient to verify that which decision was taken at which meeting. Now the question arises how these meetings are to be numbered. For that, there is a guidance note to Secretarial Standard 1 which provides a detailed procedure of this numbering. The guidance note says that if a company is, normally some of the companies have already given their numbers to their board meetings. Suppose we are today in 2017 and a company was incorporated way back in 2000, so they have been numbering all their meetings. And suppose they have done 60 meetings or as on or before 1st of July 2015, the cut-off date. After that, they will continue having the same numbering, that 61, 62, 63, 64. If the company has not numbered its meetings, then the guidance note has advised that companies may start numbering their meetings now. Now means 1st July 2015 onwards. Then here in this case, either they may start the numbering from the beginning or the since the date of the incorporation. But in that case, the company has to write in the minutes that earlier company was not numbering its meetings, but now the company has started numbering its meetings, so that it doesn't look like the company's first meeting was in 2015 only. Another option which has been given to the company does not give numbering to its meetings which were held on or before 1st July 2015. Now the company starts meeting 1, 2, 3, 4, 5. The third option which has been provided by the guidance note to the company is the company may have the numbering of its meetings on the basis of the calendar year. Say 1 of 17, 2 of 17, 3 of 17, 4 of 17, 5 of 17, and next year 1 of 18, 2 of 18, 3 of 18 and onwards. Fourth option which has been provided to the company is on the basis of the calendar year. Numbering on the basis of the calendar year. 1 of 16, 17, 2 of 16, 17, 3 of 16, 17, 4 of 16, 17, and then next year 1 of 17, 18, 2 of 17, 18, 3 of 17, 18, and likewise. But whatever the system the company adopts once, the company has to adopt that system on permanent basis, and that is why it is written there. The system has to be consistent and uniform for all purposes. The third poser which is here is, can board meetings be held on Sundays, public holidays and national holidays? Now there is some confusion here amongst the stakeholders. Because earlier the board meetings were not being held on Sundays and public holidays. And now the Companies Act 2013 says that if a meeting has been adjourned for want of quorum, that the adjourned board meeting cannot be held on a national holiday. Further, if you refer to Form MR3, which is Secretarial Auditor Report, that auditor report says that Secretarial Auditor has to confirm that the board meetings have been held on. Sorry, I'm sorry here, it's cut off. The MR3 I'll come to later on. Then further, there is a provision for holding an annual general meeting. In case of annual general meeting also, the law is very clear that annual general meeting cannot be held on a national holiday. Further, the law further says, Companies Act, that an adjourned annual general meeting cannot also be held on a national holiday. So taking a cue from all this, that adjourned board meeting cannot be held on a national holiday, AGM can't be held on a national holiday, and adjourned AGM also cannot be held on a national holiday. Take a cue from this, the Secretarial Standard has provided that even the original board meeting cannot be held on a national holiday. So now, as per Secretarial Standard, the board meeting, whether it's original or adjourned, cannot be held on a national holiday. And the national holiday has been defined in the Secretarial Standard itself. National holiday means Republic Day 26 January, 15th August, Independence Day, and Mahatma Gandhi birthday 2nd October, or any other day which may be declared as a national holiday by the central government. Now, holding of original meeting on a national holiday is a debatable issue, and hope the law will settle down very soon. Next question is, should the notice be given of board meetings even if meetings are held on predetermined dates or predetermined intervals? What does it mean? Suppose today is 12th of May. Today company holds a board meeting. And today the company decides that the next board meeting shall be held on 1st July 2017. Now the question arises whether for the board meeting to be held on 1st July 2017, the date of which has already been decided, that today's board meeting on 12th May 2017, should a fresh notice is required to be given to the directors for holding a meeting on 1st of July 2017. The answer is there in the standard, and it says yes, a separate notice is required to be given for each and every board meeting. Now how the notice is to be sent. First of all, the notice has to be in writing. It cannot be sent through WhatsApp or through messages, though that's also writing mode, but it cannot be sent in that mode. Now how the notice is to be sent. The notice may be sent. The 5 different modes have been provided in the standard. Notice may be sent either by hand, notice may be sent either by registered post, or by speed post, or by courier, or by email. Now if the company is sending a notice by email, then the company has to use a secured computer system which is capable of generating the record of sending the notice as well as the proof of delivery of that particular notice through email. If your computer system is capable of having this auto-generating this record, then only you can use this email system. Otherwise, you cannot use this email system. Then you have to send the notice through any other those 4 modes. Now, what is the minimum time period for sending the notice, agenda and agenda notes for board meeting? Companies Act 2013 talks about that 7 days notice shall be given for holding a board meeting. Companies are silent on the time period for sending the notice and agenda and agenda notes. Now I refer to Form MR3 Secretarial Auditor Report, which was by mistake I was referring earlier. This Form MR3 Secretarial Auditor Report mentioned that Secretarial Auditor has to confirm the notice, agenda, notes and agenda has been sent to all the directors at least 7 days in advance. It means, as per Secretarial Auditor Report, the notice, agenda, notes and agenda have to be sent to all the directors 7 days in advance. Again, taking a cue from this, the standard has provided that in all the companies, the notice, agenda and notes and agenda shall be sent to all the directors at least 7 days in advance. Now, how to compute this 7 days? Is it 7 clear days? Is it 7 working days? Or what is the computation of these 7 days? It's very simple. The date of the notice plus 7 days. Suppose today is 12th of May and the company is sending a notice today. 12 plus 7, 19. 19th May is the earliest possible date on which the company may hold its board meeting. However, the standard further provides that if a notice is being sent by courier, by speed post or by registered post, then in that case 2 additional days shall be added to these 7 days to ensure that, because normally it is taken, is presumed that all the delivery through these 3 modes takes at approximately 48 hours. Hence, after the expiry of 48 hours, all these documents, the notice, agenda, notes and agenda reach the director at least 7 days in advance. Next exposure is, can supplementary notes be circulated at or before the meeting? Now, what exactly does it mean? Suppose a company has sent the notice and company has sent the agenda and notes and agenda. Everything has been sent to all the directors 7 days in advance. Now, in case of a particular item of agenda, the agenda notes have already been sent, but some new information comes to the knowledge of the company secretary, and the company secretary thinks that this particular information should also be shared with the directors, but the time gap between the sending of this information, additional information, and the board meeting is less than 7 days. Can this supplementary note on the item of agenda already listed there can be sent at a period which is less than 7 days? The standard provides an answer to this. Standard is yes, this information can be provided, can be sent to all the directors, or can be even tabled before the meeting, subject to the consent of the majority of the directors present at the meeting, which shall include one independent director if any. What is the meaning of this term, one independent director if any? It means if the company is having independent directors, and if any of the independent directors is present there, then this majority of the directors present should include that independent director. In that case only the supplementary information can be taken on record at the meeting of the board. Can a board meeting be called at a shorter notice? You just now heard that board meeting can be called by giving a 7 days notice. Now whether a shorter notice board meeting is also permissible and possible. Companies Act, yes, talks about this. Companies Act says that a company may convene a meeting of the board at a period which is shorter than 7 days, subject to the condition that the particular meeting is attended by at least one independent director. Now if the meeting is not attended by any independent director, then the minutes with respect to this meeting shall be final only if the minutes are ratified by at least one independent director. So here the importance which has been given to the independent directors by Companies Act itself. I am repeating it again. A meeting may be called by giving a shorter notice provided the meeting is attended by at least one independent director. If no independent director is present at the meeting, the decisions taken at this meeting shall be final only if they are ratified by at least one independent director. Here the word used is ratified. Normally in case of minutes we see the director who does not respond to the draft minutes if they are sent to him for comments. If the director does not respond, it is taken as his approval. But here that approval is not there. Here there is a specific ratification. The director, independent director has to specifically ratify the decisions, only then the minutes with respect to this meeting shall be final. Now friends, the question arises, in all the companies they are not independent directors, and all the companies under the Act are not required to appoint independent directors, and further, even if a company which may be required to appoint an independent director but the company has not appointed independent director, what will happen in that case? Whether those companies can call a meeting of the board at a shorter notice or not. Your standard provides a solution to this. Your standard says yes, in case of companies where there is no independent director, even those companies may also convene a meeting of the board at a shorter notice provided the meeting is attended by the majority of the directors of the company, and if the meeting is not attended by majority of the directors of the company, then the decisions taken at the meeting shall be final only when the decisions are ratified by majority of the directors of the company. I just give an example. Suppose in a company there are 10 directors. Now out of 10 directors, 4 are present at the meeting. As per the Act, the quorum is there because quorum is 1/3 or 2, whichever is higher. In this case the quorum is 4 and 4 directors are present at the meeting. And this meeting has been called at a shorter notice. Though there is perfect quorum, item is discussed, decided by all the directors, but the decision taken at this meeting shall be final because this meeting has been called at a shorter notice. The decision taken at this meeting shall be final only when the minutes are ratified by at least 2 more directors, which means 4 plus 6, which constitutes the majority of the total number of directors. So once the minutes are ratified by 2 more directors, then only the minutes of this meeting shall be final. Next poser, friends, is can agenda notes on items of business which are in the nature of unpublished price sensitive information be given at a shorter period of time? We just understood that notice, agenda, notes and agenda have to be given at least 7 days in advance. A meeting may be called at a shorter notice also. Now coming back to the 7 days in advance. The question is now, whether a price sensitive information can be sent to the directors. This notice is not a shorter notice. The meeting is not at a shorter notice. Perfect notice has been given, and along with the notice we have to give that agenda, notes and agenda also. But there is one particular item which is very very price sensitive in nature. The agenda notes with respect to this particular item, can these agenda notes be sent to all the directors at a period which is less than 7 days, or can these agenda notes be tabled or placed before the board meeting? For this, friends, we need to understand what exactly is the meaning of price sensitive information. The word used is unpublished price sensitive information. Number one, that this information is very very price sensitive. Number two, this information is unpublished, means it's not published, it's not in public domain. And why it's called price sensitive? Because so far it is unpublished. The moment it is published, there may be variation in the price of the stock price of the company. Hence it is called unpublished price sensitive information. Now if this information is given to all the directors, say 7 days in advance, there may be possibility that some of the information is leaked out. And once the information is leaked out, this information may have havoc in the market. There may be some insider trading also in the market. So from this point of view, it was discussed whether this UPSI can be given to the directors at a period for which is less than 7 days, or can it be tabled before the board or placed before the board. These 1, 2, 3, 4, 5, 6, 7 bullet items, I hope a camera is here on this. These 7 bullet items have been considered as unpublished price sensitive information. First one is periodical financial results of the company. Friends, please note that this is periodical financial results. It's not annual financial statement. It is periodical financial result, which includes your quarterly financial results also. Second is intended declaration of dividend, which is final dividend as well as interim dividend. Issue of securities or buyback of securities. Any other major expansion plans or execution of new projects. Amalgamation, mergers or takeovers. Disposal of the whole or substantial part of the undertaking, or significant change in policies, plans or operations of the companies. These 7 items have been considered as price sensitive information. Now if any information with respect to these 7 items has been unpublished so far, then the question arises whether this information can be sent to all the directors to be considered at a meeting of the board for a period which is less than 7 days, or can it be tabled before the meeting. The answer to this has been provided in the standard itself, and it says yes, it is possible, it is permissible, but with the consent of the majority of the directors of the company, which shall include at least one independent director if there is any independent director on the board of the company. Now next question arises whether the consent of the directors is required to be taken at every board meeting. Here also the solution has been provided. No, it is not required to be, the consent is not required to be taken at every board meeting. The consent may be obtained by the company in the very first board meeting of the company of the financial year. However, if there is any change during the year in the constitution of the board and that disturbs the majority which has given its consent for placing of these items at a period less than 7 days, then in that case, the moment there is a change in the constitution of the board, this consent is required to be taken again by the board. Now the next bullet, friends, is, which is very very important, and which is very very practical also in almost all the companies, in all the board meetings, in all the agendas. It says, can any item not included in the agenda be taken up for consideration at the board meeting? In every board meeting agenda, friends, you will find at the end of the agenda, one item is invariably there, any other item with the permission of the chair. But this particular item has been grossly misused also by many companies. And by this way, they have really oppressed the minority directors or minority shareholders of the company. Law says that notice agenda, notes and agenda have to be given to all the directors at least 7 days in advance. So the directors, before they come for the attend the board meeting, they come prepared, they go through the agenda notes, and when at the meeting, they come prepared and have a significant proper discussion at the meeting. Now, if any item which is very, very important in nature, if it is tabled before the meeting under any other item, but the directors have not got time to go through that item, can this particular item be considered or discussed at a meeting of the board? Should be allowed to be continued? Should this practice be allowed to continue or not? But yes, simultaneously there are very, very urgent and reasons also that an item which could not be listed in the agenda earlier, but now the urgency is there and same is required to be considered by the board, and board's approval is required for that particular item. So what will happen in that case? Should the companies be totally debarred, or should the companies be totally allowed to continue with this item, any other item? Here the standard has come to the rescue of the stakeholders. Standard says that any item under this particular item, any item with the permission of the chair can be discussed with the permission of the chairman of the meeting, as well as also with the consent of the majority of the directors present, which shall include at least one independent director, if any. So all these three conditions have to be met before any item can be taken up for consideration under any other item. Permission of the chairman, consent of the majority of the directors present, which shall include at least one independent director. Now suppose no independent director was present at the meeting. Then in that case, the provision is with the consent of the chairman, with the permission of the chairman, and with the consent of the majority of the directors present, and then the minutes with respect to this particular item, not with respect to other items, minutes with respect to this particular item which has been discussed under any other item shall be final only if the minutes are ratified by at least one independent director. This is a situation where no independent director is present at the meeting, but the company is having independent directors. Now the next situation is that the company is not having independent directors on its board. So what will happen in case of those companies, whether those companies can consider any item under the head any other item at the meeting of the board? Again, the standard has come to the rescue of the corporates. It says that yes, it is possible if this particular meeting is being attended by majority of the directors of the company. Yes, then in that case, any item may be discussed under the head any other item. Now suppose if the majority is not present at the meeting, then what will happen in that case? Then recall the earlier provision of meeting call at a shorter notice. In this case also, the minutes with respect to this particular item shall be final only if the minutes with respect to this item are ratified by majority of the directors of the company. I am taking the same example again. Suppose there are 10 directors on the board of the company and 4 are present at the meeting. Meeting is proper notice has been given, 7 days notice, agenda notes and agenda. However, at the meeting now, these 4 directors, the chairman decide that one particular item is required to be taken which is not listed in the agenda. One of the director raises this item. Chairman gives its accord. Okay, yes, you may go ahead, we can discuss this item. This item is approved by the directors present there, who are 4 in number. But now the standard says that this item shall be final, the decision with respect to this item shall be final only if the minutes with respect to this item are ratified by majority of the directors, means at least by 2 more directors, 4 plus 2, 6, then it becomes the majority of the directors because the total strength is 10 here. Quorum. What is the quorum for a meeting of the board? The quorum has been provided in law also, that 1/3 of the total number of directors or 2, whichever is higher, shall be the quorum, and unless a quorum is present at a meeting of the board, no business can be transacted at a meeting of the board. Even the meeting, the proceedings cannot even initiate, cannot even start, cannot even commence unless the proper quorum is there. Now the next posture is, friends, what will happen if quorum is not present at the meeting? What will happen in that case? Company called a meeting. Suppose the same case, 10 directors, quorum is 4. Now at the meeting only 3 directors are present. Now here the standard says, unless the articles of the company provide otherwise, the meeting shall stand adjourned to next week, same day, same place, same time. And if that day happens to be a national holiday, to the succeeding day, same time, same place. Now the next question is, at the adjourned meeting also there is no quorum. What will happen in that case? The meeting was called earlier, quorum was not there, meeting was adjourned to next week, same day, same place, same time. At the adjourned meeting also there is no quorum. Here there was a long debate on this particular item. So one of the views was that members present shall form the quorum, but the standard ultimately finally provides that if at the adjourned meeting also the quorum is not there, the meeting shall stand cancelled. It will not be adjourned further. Now what is the frequency of the board meetings? Companies Act 1956 provided that there shall be 4 board meetings in a year, and at least 1 board meeting shall be held in 1 quarter. And one quarter means a block of 3 calendar months. So that way, Jan, Feb, March, 1 meeting, April, May, June, 1 meeting, July, August, September, 1 meeting, and October, November, December, 1 meeting. This is as per Companies Act 1956. Now it means if the company holds its first meeting on 1st January and the next meeting on 30th of June, now there are 2 meetings in 2 different quarters, but the gap between the 2 meetings is now approximately 6 months. But this is a due compliance of law as per 1956 Act. Companies Act 2013 as well as LODR, the listing regulations, provide that there will be at least 4 board meetings in a calendar year. However, the gap between the 2 consecutive board meetings shall not be more than 120 days. So both the conditions have to be met simultaneously. Now I just pose a query before you. Suppose a company convenes its first board meeting on 1st January, second board meeting on 2nd January, third board meeting on 3rd January, and fourth board meeting on 4th January. The law says 4 meetings in a calendar year. Here is this requirement is met. The gap between the 2 consecutive board meetings shall not be more than 120 days. Yes, in these 4 cases, in these 4 meetings, the gap is between the 2 consecutive meetings is not more than 120 days. Now this company does not hold any other meeting during the calendar year. The question is it due compliance of law or not? Answer is no, because now the 5th board meeting has to be held within 120 days of the 4th board meeting. If the company does not hold any other meeting during the calendar year, it will be a non-compliance. Next question is, friends, from which date should the gap of 120 days be counted for holding the next board meeting? From the date of the original board meeting or date of the adjourned board meeting? I'll just give you an example here again, practical example. It will be very easy to understand this particular provision. Suppose a company holds its first board meeting on 1st of January. This meeting stands adjourned. The quorum is not there. This meeting stands adjourned to 8th of January. Now the next board meeting has to be called by the company within 120 days of the original board meeting. Meaning thereby 120 days shall be counted for the next board meeting from 1st of January and not from the 8th of January. Another question which arises here, I just give you a practical query on this. Suppose the company holds its first board meeting on 1st of January and the next board meeting the company convenes on 27th of April. It's a due compliance. The gap between the two board meetings is not more than 120 days. But on 27th of April, there is no quorum in the board meeting. So what will happen? As we just understood, that unless the articles provide otherwise, the meeting shall stand adjourned to next week, same day, same time, same place. And the next week, same day, same time, same place happens to be 4th of May, which is beyond 120 days from the earlier date, 1st of January. So whether this meeting which the company is holding, adjourned board meeting holding on 4th of May, is it a due compliance of law or not? Answer is no. Even the adjourned board meeting should have been held by the company within 120 days of the first meeting, of the last meeting. So in this case, the company should endeavor that by all means company holds its second board meeting on or before 30th of April. Next proposal, friends, is what should be the mode of communications of request for leave of absence by directors, and to whom the request for this leave be communicated by the director. Friends, if you recall, those who have read Companies Act 1956, that act provided that a director may apply for leave of absence. Even that provision is here in this law act also. However, that act provided, 1956 act provided, that if a director does not attend 3 consecutive board meetings of the company without leave of absence, then the director shall cease to be director. He has to vacate his seat, and it's an automatic vacation. So that is why what was happening in earlier times, in majority of the cases, any director who did not attend the board meeting was being shown as, in the minutes book, leave of absence was granted to so and so. So any director, whether he attended the meeting or not, but in the minutes always showed the leave of absence was granted. Once you grant leave of absence, then this disqualification, the provision relating to vacation of office, does not arise at all, because the provision said if the director does not attend 3 consecutive board meetings of the company without leave of absence, then he shall cease to be director. But here in this case, the company used to provide leave of absence on continuous basis to all its directors who did not attend the meeting, and hence the directors continue to remain on the boards of the company. But now the Companies Act 2013 has come on very heavily on all these directors, and the act says now any director who does not attend the board meetings of a company for a consecutive period of 12 months, then that director shall cease to be director. I am repeating it again. If a director does not attend board meeting of a company for a consecutive period of 12 months with or without leave of absence, then that director shall cease to be director of the company. Now the provision here is with or without leave of absence. Even though the leave has been applied for and leave has been granted, but still that is absolutely immaterial. If a director does not attend board meetings for consecutive period of 12 months, the director shall cease to be director. Whether leave was granted to him or not, absolutely immaterial. The next question which arises here is that from which date you have to count this period of 12 months. From the last meeting he attended, or the first board meeting which he did not attend. Again, I give an example. I come to my original example. On the 1st January 2017, the company holds a board meeting, and X, a director, attends this board meeting. Now, the next board meeting is held on 27th of April 2017. X, the director, does not attend this board meeting, and for rest of the calendar year, the director does not attend any other board meeting. Now 2018 comes. Now the question arises, till what period the director, if he does not attend a board meeting, till what period if he doesn't have a board meeting, and he will cease to be director of the company. Here in this case, the 12 months should be counted from the 1st January, the meeting which he attended, or from 27th of April 2017, the first board meeting which he did not attend. The answer is the 12-month period shall be counted from 27th of April and not from 1st of January. Now this 12-month period shall expire next year on 27th of April. However, a further relaxation has been given that the 12 months period in this case shall be counted, the entire calendar month of April shall be counted for this purpose. Hence, he will be disqualified. He will vacate his seat if he does not attend any board meeting till 30th of April 2018. Sorry, I am coming to this previous slide again. Here the question was, as I said, the director has not attended the meeting with or without leave of absence. Now the question arises here is how this leave is to be applied for and to whom the leave is to be applied for. Is it necessary to apply the leave in writing only? Answer is no. Why so? I give you a practical example. Suppose today is 12th of May and I receive, I'm a director on the board of a company whose office is in Mumbai, and I receive a notice today that the next board meeting is on 25th of May. Meeting is at 2 p.m. I receive a notice, agenda, notes on agenda today, everything I receive. Then I ask the company to book a flight ticket for me at a 9 a.m. flight from Delhi to Mumbai, so that I will be there at 11 a.m. I will reach the company's office at 12:30 or so, and meeting is at 2 p.m. On 25th of May, I reach the airport. But once I reach the airport, I come to know that the flight has been delayed by 4 hours, and it may happen with anybody. Now the flight is scheduled to depart from Delhi at 1 p.m. Meeting it is Mumbai at 2 p.m. Now I think the meeting is going to last for a couple of hours. I will be landing there at 1 p.m. It will take me another half an hour, 45 minutes to come out of the airport, another 1 hour drive to the reach company's office. By that time it will be 3:34 and the meeting will be over. So I decide at Delhi airport on 25th itself, let me not go, let me cancel my trip, and I am not going to attend the meeting. But in this case now I think I propose to apply to the company for leave of absence. Now here in this case, applying the leave of absence is not practically possible to be given in writing. So what will I do? I'll simply call the chairman of the company or the company secretary of the company and tell them the genuine reason. These are the reasons I have not been able to come because of the delay in flight. Hence, a leave of absence should be granted to me. Now, the chairman and company secretary, when the minutes will be written, they are under an obligation to mention in the minutes that such and such director applied for leave of absence, and for what reason the leave of absence was applied for, and to whom the leave of absence was applied for. So the leave may be applied for either in writing or through telephonically or through email or through WhatsApp or through messages. All of these modes are possible. However, the fact of applying this leave and to whom the leave was applied has to be mentioned, referred in the minutes book of the company. Next question, friends. Is it mandatory to provide video conferencing facility to the directors for participating in the meeting? This is an issue where multiple interpretations are possible. However, what I'll discuss as whatever has been provided in the standard as on date, that any director, the participation of a director in a meeting of the board may be through physical mode or through video conferencing. However, if the company is not providing this facility, the director may always ask for this facility, and in that case, as per the law as on date, the company may say no, we are not in a position to provide you the video conferencing facility. But this provision is, friends, subject to further debate also, and law is yet to settle down on this particular issue, whether it's a right of the director to give this facility or it's a right of the company to option of the company to give this facility. However, whenever a meeting is being held through video conferencing, the rules, Rule 4 of the company board meeting rules, they say that there are 5 restricted items which cannot be discussed, which cannot be dealt with at a meeting held through video conferencing. and these items are listed here. Item 1 is, these are 5 bullets are mentioned here on the screen. First bullet is on approval of the financial statements. Friend, this is approval of the financial statement. It's not approval of the financial results. It's not quarterly results. It's not periodical results. It's approval of the financial statements, and financial statement has been defined under the Act, annual audited financial statement, which comprises of balance sheet, profit and loss, cash flow statement, and so and so. The second item is approval of the board report. The third item is approval of prospectus. Fourth is matters relating to amalgamation, merger, demerger, acquisition and takeover. And fourth item is pertaining to the meeting of the audit committee. When this audit committee considers again the financial statements, not the financial result but the financial statement, then in that case also this item cannot be considered at a meeting of the audit committee if the meeting is being held through video conferencing. So the 4 items, first 4 bullets are in relation to board meetings, the 5th item is in relation to audit committee meeting. If the meeting is being held through video conferencing, then these items cannot be dealt with at such a meeting. However, the standard has come out with a carving out provision, and standard says that if any director is participating through video conferencing and any of these issues come up for discussion, then in that case the director who is participating through video conferencing may participate on the particular item through video conferencing with the permission of the chairman of the meeting, provided further that it is to be ensured that physical quorum is present there. Further proviso is that this particular director can only participate in the discussion but does not have any right to cast his vote on any of these items. And whatever the provision I have discussed just now regarding participation through board meeting and through video conferencing in the board meeting, all these provisions are part of the Friends Companies Amendment Bill 2016 also, which is pending before the Parliament for its consideration and approval. Now the question arises whether if in a particular item a particular director is interested, can the director participate in the discussion or not? Can he remain present in the boardroom or not? Or if what will happen in case in that particular item the chairman of the meeting is interested? Answers to all these questions are given in the standard, friends. A director who is interested in a particular item of agenda, the moment that item comes up for discussion, this interested director will not participate in this discussion. However, he will remain present in the boardroom. Further, if the chairman of the meeting is interested in a particular item, then in this case the chairman shall vacate the seat of chair, will assign the chair to somebody else with the consensus of the directors present, and once this item is over, then again he can resume the chair. But in this case the chairman will also may remain in the boardroom. They need not vacate the boardroom. The next question is, if this particular item is a related party transaction, then what will happen in that case? Then in that case, if the item is a related party transaction, that whichever director is related in this particular item, or even if the chairman of the meeting is related in that particular, is a related party in that particular item, the director or the chairman, as the case may be, have to vacate the boardroom also. They have to leave the boardroom also, and once this item is over, then they can again join the meeting and enter the boardroom. So if the chairman is a related party in a particular item, then for this purpose also, for this item, the chairman will vacate the seat, assign the seat of chairman to somebody else with the consensus of the directors present. He will leave the boardroom. Once the discussion on this item is over, then he can again enter the boardroom and participate in the further items of agenda. Next poser, friends, is whether the quorum is required to be present at the beginning or throughout the meeting. Answer is, unless the quorum is present, the business of the meeting cannot commence. However, the standard further stipulates the quorum has to be present throughout the meeting for each and every item of agenda item, including if when there any other item is also been discussed, even that point also the quorum has to be present there. Unless a quorum is present, no business can be transacted at a meeting. And suppose at the beginning of the meeting quorum is there, for next couple of hours quorum is there, then all of a sudden the quorum, the number of directors fall below the quorum prescribed. Then in that case, the meeting has to end here and the minutes shall prescribe now the no quorum was present, hence the meeting ended. Meaning thereby again that no business can be transacted at the meeting unless a quorum, valid quorum is present at the meeting. Now I come to the attendance register. Every company has to maintain the attendance register with respect to its board meetings and with respect to its committee meetings. The separate attendance register is required to be maintained. And in this attendance register, the standard has distinguished between the participants in two categories. Category 1 is attendees and category 1 is invitees. Attendees means all the directors and the company secretary shall be attendee, while any other person who has been invited to attend the board meeting shall be treated as invitee. Suppose group CFO is there, suppose statutory auditor is there, suppose internal auditor is there, suppose cost auditor has been invited, suppose secretarial auditor has been invited, suppose for a particular item of the agenda some vendor has been invited to attend the board meeting. In all these cases, all these invitees shall be treated as invitees, while the directors of the company and the company secretary are treated as attendees. Now all these attendees and all these invitees have to sign the attendance register. And friends, this practice is also not being followed in most of the companies. All the attendees and all the invitees have to sign the attendance register, and when the minutes of this meeting shall be recorded in the minutes book, the minutes shall also mention the names of all the attendees and all the invitees. Even though I am repeating again that even though a particular individual has been invited for a particular item of agenda, even that particular the person has to sign the attendance register and his name shall be mentioned as an invitee in the minutes book also. Next question is, can the chairman adjourn the board meeting at any stage of the meeting without assigning any reason? The answer to this is yes, it's possible. However, the standard says the chairman may adjourn a meeting of the board without assigning any reason, provided his decision is not objected to or is not dissented by the majority of the directors present at the meeting. Friend, the provision is not that the chairman can adjourn it with the consent of the majority of the directors. The provision is the chairman may adjourn the meeting provided his decision of adjournment is not objected to or dissented by the majority of the directors present. Now I come to the provisions relating to chairman. Now there is a lot of confusion on this particular provision, that who can chair and which meeting. Standard has clarified this position absolutely. It says that the chairman of the company, if any, if the company has a chairman, then in that case the chairman of the company shall be the chairman of the board, and the chairman of the board shall preside over all the board meetings and general meetings of the company. Second, if there is no chairman of the company, then the directors of the company shall elect one of themselves to be the chairman of the board, and this chairman of the board shall preside over all the board meetings and all the general meetings of the company. Next scenario, if there is no chairman of the company, or the directors of the company have not elected one of themselves to be the chairman of the board, or if there is a chairman of the board but that chairman of the board is not present at the board meeting, or the chairman of the board is present at the meeting but he is not willing to chair the board meeting. In all these scenarios, the directors present at the meeting shall elect one of themselves to be the chairman of the meeting, and this director so elected as chairman shall be the chairman of the meeting only, will not be called as chairman of the board. I am repeating this provision again. If there is no chairman of the company, or if the directors of the company have not elected one of themselves to be as chairman of the board, or the chairman of the board, though elected, is not present at the board meeting, or the chairman of the board is present at the meeting but is not willing to act as chairman of the meeting, then in that case the directors present at the meeting shall elect one of themselves to be the chairman of the meeting. This provision is again, friends, mutatis mutandis, applies to the committee meetings also. It's a prerogative of the board to constitute the committee meetings, barring those statutory committees which have been prescribed by Companies Act as well as by listing regulations or by any other law for the time being in force. While constituting a committee, the board may decide that which director is going to chair this particular, who is going to be the chairman of this committee. Now, if the board has board has designated one of the directors as the chairman of the committee, it's fine. But if the board has not done so, then in that case the members of this committee may elect one of themselves to be the chairman of the committee, and this chairman of the committee shall preside over all the committee meetings. Now suppose the board has not designated any director as chairman of the committee, and the directors, the members of this particular committee have also not elected one of themselves to be as chairman of the committee, or if they have elected but the chairman of the committee is not present at the committee meeting, then in all these scenarios the members present at the committee meeting shall elect one of themselves to be the chairman of the committee meeting. Not chairman of the committee, but the chairman of the committee meeting, who will preside over this particular meeting only. Now I come to the provisions relating to resolution by circulation. Whenever an urgent item comes before the board or before the managing director or chairman, and it decides that an urgent item is required to be discussed and decided by the directors and has to be acted upon immediately, and it's not convenient to call a meeting of the board, or some of the directors are not here, they have already gone abroad, or it's not practically feasibly possible, it's not viable also to convene a meeting of the board, then in that case an urgent item of a business, urgent item can be discussed by circulation also, unless the law otherwise provides that a particular item can be discussed at the meeting of the board only. But if the item is not a compulsory item to be discussed at the meeting of the board, then any other item may be discussed by the directors by way of a circulation also. It can be discussed and decided. What happens in this case? The company secretary shall prepare a note on the item to be discussed by circulation. This note, along with the explanatory papers attached thereto, along with a copy, a draft resolution, he will prepare a draft resolution also. He will send all these documents, draft resolution, note and the explanatory documents, agenda notes, to all the directors. How these documents shall be sent? Again in any of those 5 modes: by hand, by courier, by speed post, by registered post, or by mail. The directors shall be given not more than 7 days to respond to this resolution, which has been draft resolution, which has been sent to them by circulation. Now what the directors can do with this draft resolution? Either they may give their assent, or they may give their dissent, or they do not reply to this at all and they remain silent on this. If they remain silent on this, they shall be treated as absentees. Friends, in this case, as it is not a board meeting, there is no question of having any quorum in this, because this is a resolution by circulation. Now once these documents are sent by the company secretary to all the directors are given not more than 7 days time to respond to this. But now the Companies Act 2013 says that if 1/3 of the directors, if they think and if they write to the company before the last scheduled date that this item of business should be transacted at a meeting of the board only and cannot be passed by circulation, if at least 1/3 of the directors of the company write to the company like this, then in that case, even though this item has been approved by majority of the directors, still this item cannot be acted upon, it shall not be deemed as passed, and it has to be taken to the board only at its meeting for its consideration and approval. Normally, all the decisions are taken by way of circulation by majority of the directors only. But if one third of the directors, if they write to the company that item has to be taken to the board, can be discussed at the meeting of the board only, then this item cannot be discussed by circulation. Now I give you one example. The same example, today is 12th of May and the company has 10 directors. Now today the company secretary sends a draft resolution along with the note on this, along with the explanatory note also and agenda paper so and so, to all the directors, and tells them, okay, the 19th May is the last date for the director to respond to this particular draft resolution. There are 10 directors. Now suppose 6 directors, they respond tomorrow, 13th of May. For all practical purposes, friends, this resolution is passed, has been approved by majority. But the remaining number, which is 4, which is more than 1/3, they always have got the right to write to the company on or before 19th of May that this item has to be taken to the board for its consideration and it cannot be passed by circulation. So unless this number, the remaining number is less than 1/3, this resolution shall not be deemed to be passed. Now suppose tomorrow is 13th and 6 of directors give their assent in this favor. On 14th, one director sends his dissent to the board, dissent to the company. Now the situation as on 14th is, out of 10, 6 are in favor, 1 is against. Now the remaining number is 3, which is less than 1/3. Now even though those 3 directors write to the company later on that item has to be discussed at the meeting of the board, but as this number is less than 1/3, their opinion, their view or their communication to the company is not binding of the company, and now this item shall be deemed to have been passed on 14th of May, because on 14th of May the majority of the directors are in favor of the resolution and the remaining directors who have not responded are less than 1/3 of the total number of directors. Another example in this series is, friends, suppose only 6 directors respond to the company on 13th and all of them are in favor. Now company has to wait till 19th. Suppose no other director responds, the company has to wait till 19th, and if till 19th no other director responds, the resolution shall be deemed to have been passed on 19th, because in this case it is not passed on 13th but shall be deemed to have been passed on 19th only, and only after 19th this resolution can be acted upon by the company. Now see the last bullet, when a resolution by circulation shall be deemed to have been passed. If I gave you 2 examples. In first case 6 voted in favor on 13th and 1 dissented on 14th. In that case the resolution shall be deemed to be passed on 14th. In the second example which I gave, I said that on 13th 6 directors give their assent, no other director responds, the company has to wait till 19th, then the resolution shall be deemed to have been passed on 19th only. What will the treatment if a director does not respond? As I said, the director shall be deemed to have remained absent, and this fact of his remaining absent from the resolution shall be mentioned in the minutes book. Now if the majority of the requisite if the approval of the requisite majority is not received by last date, will the resolution lapse? Suppose in this case 10 directors are there, 5 directors respond by tomorrow, that is 13th, and no other director responds till 19th. What will happen to this resolution? Will it be treated as passed? Answer is no, because the resolution has to be passed by majority of the directors, and the majority is 6 in this case. As the resolution has been approved by only 5, no other director has responded. Company has to wait till 19th. On 19th, the resolution will lapse, it will fail, it will not be treated as passed. From which date the resolution so passed will be effective? The resolution shall be treated as effective either from the date of its passing or from the date which has been mentioned in the resolution itself, that from which date the resolution shall be deemed to have come into force. Suppose the resolution says, which is passed, if suppose in this case the item number, first example, 12th the company is sending it, on 13th the company is receiving assent from 6 directors. No other response comes. Then in this case, the resolution shall be deemed to have been passed on 19th, because no other response has come, company has to wait till 19th. Suppose the resolution says the resolution shall become effective from 1st of June. Then though the resolution has been passed on 19th, but as the resolution, the content of the resolution itself says the resolution shall be effective from 1st June, it will be effective from 1st June only. Now the next question is, will the resolution so passed be ratified in the next board meeting? And friends, I tell you, majority of the companies are doing it. Any resolution which is passed by circulation, they take this resolution to the next board meeting either for confirmation or for ratification. The item of the agenda is to ratify the resolution by circulation passed on 19th of May so and so. My question to those companies, suppose they take this item for ratification and the board meeting, the resolution does not get ratified. But the resolution has already been passed on 19th of May, has been acted upon also. Suppose the company applied for a term loan from a financial institution, or suppose any other item is there, an item has been passed by the board by circulation, and later on the company has entered into an agreement also with that particular authority, particular lender or any other party, and this resolution, the agreement has been acted upon also. Now the next meeting the company is taking up this item for ratification. If this item is not ratified there, what will happen to the action already taken? Because the resolution has already been passed. Hence it is advised and that in the next board meeting this particular resolution which has been passed by circulation should be taken for noting purposes only. No ratification, no confirmation, no approval. In the next board meeting, the resolution passed by circulation shall be taken up for noting purpose only, and the agenda item may be to take note of the resolution passed by circulation on 19th of May 2017. That's all. Now I come to the minutes, a very, very important part of this board meetings and proceedings. The first bullet item is whether distinct minutes books are to be kept by the board and committee meetings. Answer is yes, the minutes books have to be separate for this purpose. How the minutes are to be maintained in electronic form? The minutes have to be maintained in electronic form with a time stamp, and time stamp has been defined in the Secretarial standard itself. How the numbering of pages of minutes book is to be done? The minutes book have to be numbered on consecutive basis. Consecutive numbering of the minutes book shall be there. Suppose that there is a minute book number 1 and the last page of the minute book is ending at page 79. The next minute book will start with the page number 80, not page number 1 again. It will not be minute book 2 and page 1. No, it will be minute book 2, but the page number will be 80. If second minutes book is ending at page 160, third minute book will start at page 161. So it has to be consecutive numbering only. Whether the minutes book are to be kept, where the minute books are to be kept, in whose custody? The minutes books have to be in the custody of the company secretary or any other authorized director, and have to be kept at the registered office of the company. If you see the Companies Act as well as the Secretarial Standard, it talks about the minutes book may be kept at any other place with the permission of the board. However, last year the rules, in September 16, the rules have been changed, and now as per the rules the minutes book can be kept only at the registered office of the company. Whether time of commencement and time of conclusion of meeting is to be mentioned in the minutes book? Answer to this is yes. Both the timings have to be mentioned in the minutes book. Where the time is required to be mentioned, it can be mentioned at the beginning of the minutes or at the end of the minutes, at any place. What is the timeline for recording and signing the minutes? This is now very, very important. And please, friends, give a special attention to this. After the conclusion of the board meeting, within next 15 days, the company secretary shall prepare the draft minutes, take those draft minutes to the chairman, and in consultation with the chairman, the company secretary shall finalize the draft minutes. All this is to be done in 15 days, and within this 15 days itself, the company secretary has to send these draft minutes to all the directors of the company. Whether any director attended the board meeting or not, absolutely immaterial. The draft minutes shall be sent by the company secretary within 15 days of the conclusion of the meeting to all the directors for their comments, assent, dissent, as the case may be. Now, during this, after the 15 days, the director shall be given 7 days time to respond to these draft minutes. Now, if during these 7 days, any of the director is sending his comment or observation on these draft minutes, then what will happen? The company secretary has to take those comments and observations of the directors to the chairman of the meeting, and in consultation with the chairman, now the company secretary will finalize the minutes. And now these finalized minutes have to be entered in the minutes book within 30 days from the conclusion of the board meeting. So what is now required to be done? Within 15 days, draft minutes to be sent to the directors. Next 7 days, directors have to respond, and in total 30 days, the minutes have to be recorded in the minutes book of the company. Once the minutes are recorded in the minutes book, the minutes are final in all respects. They cannot be altered, they cannot be modified, nothing can be deleted from the minutes, nothing can be added in the minutes. No backdating is permissible now. Once minutes are recorded, they are final in all respects and binding on the company. Now, in the next board meeting, these minutes are normally sent along with the agenda notes of the next board meeting. Now, suppose while responding to these minutes, one of the director gave his comments on any item of a particular these draft minutes, and he mentioned, he requests to the chairman, please include my comments in the minutes. But somehow or the other, those comments were not included. Now these minutes are going in the next meeting. Again, friends, these minutes shall go for noting purpose only. Again, majority of the companies are doing blunder here. They are writing in the next meeting agenda paper to confirm the minutes of the previous board meeting or to approve the minutes of the previous board meeting. No confirmation, no approval, as the minutes have already been recorded in the minutes book. They are final in all respects. Next meeting, they will go for noting purpose only. However, at the time of noting of the minutes in the next board meeting, if the director who sent his comments to the chairman, if he sees that his comments have not been incorporated, then he may mention in this meeting, in the next meeting, he may mention that he sent his comments have not been incorporated in the minutes. Now there may be separate deliberation on this item in the next meeting, and whatever the discussion takes place on this item, or whatever the discussions are held or the decisions are taken at this particular item, all this will become part of the minutes of the next meeting. In no case the minutes of the previous meeting shall be altered or changed. Now, once the minutes have been noted in the next meeting, now the question comes, who can sign these minutes? The minutes, once they are recorded in the minutes book, can be signed either by the chairman of the previous board meeting or by the chairman of the succeeding board meeting held after the date of the entering of the minutes. The minutes may be signed by any of these two. However, once the minutes are signed, within 15 days of signing of these minutes, a certified copy of these signed minutes shall be sent to all the directors by the company secretary or by any director authorized in this behalf. I'm just repeating it again. Within 15 days of signing of the minutes, A photocopy of the signed minutes shall be taken, shall be certified by the company secretary or by the authorized director, and a certified copy of these signed minutes shall be sent to all the directors within 15 days only. And friends, whatever I have discussed today so far regarding sending of these notice, agenda, notes on agenda, circular resolution, or these draft minutes or signed minutes, the company has to keep proof of sending as well as proof of delivery of all these documents. Now the next question is whether a director who ceases to be director after the board meeting is entitled to receive draft minutes. Suppose that today 12th May board meeting happens and tomorrow X director resigns from the board 13th May. Now the draft minutes shall be sent within 15 days. Whether the director is entitled for the draft minutes or not. Answer is yes, he is entitled to receive a copy of the draft minutes. Can a present director be allowed to inspect or have access to the copies of the minutes of the meetings of the board held before the period of his directorship? Suppose the director joined the board on 1st of January 2015. Today is 12th May. He is continuing as a director. During this period, can he inspect the minutes of the board meeting and can he have a copies of the board meeting before 1st of May 2015, before 1st of January 2015? Say for the year 2010, 11, 12, 13, 14. Answer is yes. He is entitled to inspect the minutes of the earlier board meetings as well as he is entitled to have a copy of those minutes also. Next question is, friend, can a director be allowed to inspect or have access to the copies of the minutes of the meeting of the board after he ceases to be director? Now same example. 1st January 2015 the director joins as a director. Today is 12th May and today suppose he resigns. After 12th May 2017, whether that director can have inspection of the minutes or take copies of the minutes of this particular company? Answer is yes. However, this right of inspection or taking copies of the minutes is restricted to his tenure of directorship with the company. It means he can inspect the minutes and take copies of the minutes of the period from 1st January 15 to 17th May 2017. Is it a prerogative of the chairman to include or exclude in the minutes the verbatim views of other directors? Yes, the verbatim views may not be recorded by the director in the minutes. Can he include or exclude from the minutes any matter as he deems fit? Answer is yes, provided subject to the condition that these comments or these matters are not defamatory or derogatory or detrimental to the interest of the particular person or the company. Whether minutes should be approved or confirmed or noted, we have discussed. Minutes can be noted only at the next board meeting. Can the minutes once entered be altered? We have discussed. No, these cannot be altered. Who can inspect the attendance register as well as minutes book? Any director of the company may inspect these two registers, register of attendance as well as the minutes book. Statutory auditor, secretarial auditor, cost auditor have been authorized to inspect the attendance register as well as minutes book. No member of the company can inspect these two documents. How the decisions taken at the meeting are to be recorded and when they can be acted upon? The decision taken at the meeting may be recorded in two forms, either in normal continued language or in the form of a resolution. Now, when these items can be acted upon, when the decisions can be acted upon, it has been very beautifully prescribed in the standard that if a draft of the resolution was placed before the board and it's been approved as such by the board, then it can be acted upon immediately after the conclusion of the board meeting. However, if no draft was placed before the board, then any decision taken with respect to this particular item can be acted upon only when the minutes are entered in the minutes book. Then only the minutes become final. Before that date, it cannot be acted upon. Preservation of minutes. Till what time office copies of notice, agenda, notes and agenda and other related papers are to be preserved by the company? The period has been prescribed at 8 years. However, the minutes book has to be preserved by the company on perpetual basis. But the copies of notice, agenda, notes and agenda have to be prepared by the company for 8 long years and later on can be destroyed with the permission of the board. However, in case there is a merger of two companies, then the notice agenda, notes and agenda of the transferor company can be destroyed by the company after the expiry of 8 years with the permission of the board as well as with the permission of the central government, not otherwise. Till what time the minutes have to be preserved? On permanent basis. And these are, friends, some of the contents of the minutes. The minutes have to contain the details of the chairman, quorum, attendance and its mode, leave of absence, how it was applied, to whom it was applied, names of the attendees, invitees, then amongst other items listed in the agenda. The views of the directors, particularly independent directors, facts of any dissent or absenteeism, fact of non-participation by interested director in an item which is interested, an item who is interested in the item, ratification by independent directors or ratified by majority if meeting is held at a shorter notice, and time of commencement, conclusion and so on. Friends, in nutshell, this was the law, practice and procedure relating to convening and conducting or holding of a board meeting. Though this law can be described, friends, I can take days together to describe all these things, but because the time is short, hence I have tried to summarize the law and practice and procedure on this particular item. And now I think the forum is open for any queries, questions of all of you, and I'll endeavor to give answer to all these questions, queries. Thank you very much. Have a nice day. Thank you.
Specific queries are from KSL.
All are the provisions of Companies Act and SS1 for holding board meetings which applicable on board meetings are applicable on committees. As I said, all the provisions of SS1 are mutatis mutandis applicable to all the committee meetings also. What should be the place of passing the resolution if board meeting was conducted through video conferencing and directors have participated from across the globe? Wherever the recording of this video conferencing is taking place, that is the place of holding the meeting. All the resolutions shall be deemed to have been passed at that place, wherever the recording of the VC is there. Can the board meeting be numbered since starting? Answer is yes. I discussed it also. Like first board meeting, second meeting, etc. Instead of naming it year-wise, yes, it is absolutely possible and permissible. Can we take numbering according to financial year like 1/16/17, 2/16/17 likewise? Yes, it is possible. I discussed. This is permissible. How to keep records of hand delivery notice? Whenever you send anything through hand delivery, please take acknowledgement of the person receiving it. Please ensure the person who is going to deliver it, he notes down the name of the person who is receiving this notice, agenda or notes on agenda. Because normally you are going to send this notice, agenda, notes on agenda to the director at his address which is registered with the company. If it is residential address, certainly one of his family member may be there. If it is the office address, certainly one of his staff or personal secretary is going to be present there. So whosoever is receiving is, please take down his signature and note his name also, his or her name also. Can a board meeting be held for giving shorter notice? Answer is yes. But you have to, if articles allowed it, but you have to follow the procedure. Otherwise, the law says a 7 days notice is required to be given. However, the articles are providing for a longer period. Then a longer notice is required to be given. Suppose the articles are saying that at least 10 days notice is required, then 10 days notice is required to be given. But if the articles are saying that 5 days notice can be given, then you have to give a 7 days notice. And if the company is giving a notice less than 7 days, then the provision of the standard have to be followed up. Should the fact that meeting was called on shorter notice be mentioned in the minutes? Answer is yes. This fact is to be mentioned. If any important item of business not being part of agenda is raised at the meeting, can it be taken under any other item? Absolutely yes, but again you have to comply with the requirement of the standard. Can an additional agenda item be circulated in less than 7 days where notice is already given before 7 days? Yes, in this case you have to comply with, as this item is any other item of the agenda, and the same principle will apply here. The provision of standard have to be complied with. If all directors of a private company are interested in a particular item, can quorum be said to have been present? In case of private companies, the exemption have been given by exemption notifications, and after disclosure of their interest, the directors of the company may participate in the discussion. What happens when adjourned board meeting is also cancelled due to lack of quorum? It stands cancelled. Is leave of absence required to be given in writing? No, writing is not required. It can be given through telephonic means, by SMS, by messages, by email. You may have any mode. And if you remember, I discussed the item, this particular provision with that I reached the airport and the flight has been delayed or cancelled. Now in that case I have only one option, only to call to the company secretary or the chairperson. To whom the leave of absence, either to the company secretary or chairperson or to the director who has, I'm reading the question again, to whom the leave of absence is required to be addressed? It should be addressed to the chairman of the meeting, or the company secretary, or the director who has issued the notice. Section 1.1, it is not applicable to Section 8 companies. Whether the institute has also come out with a notification that the Secretarial standard is not applicable to Section 8 companies. If the wife of a director is to appoint an additional director, the director would be considered an interested director in private companies that will be made permissible. How the business will be transacted in case of RPT, we have discussed. Any director who is interested in related party transaction cannot remain even present in the boardroom. Even though he is the chairman of the board, chairman of the meeting, he has to leave the boardroom, and only after consideration of this item he can again enter the boardroom. There are certain very specific cases, very hypothetical cases which have to be cannot be answered unless the full facts are before me, because I, being a lawyer, certainly cannot give answer to each and every hypothetical situation unless I need to answer some cross questioning. Also I need to have some cross questioning. I may have my own queries. Unless those queries are cleared, I cannot answer to some of these queries. As per SS1 7.2.1.3, appointment made one level below the KMP shall be noted by the board, but section 117 and rule 8 in this regard is omitted. Then whether companies still need to comply with clause with respect to noting the appointment as stated in 7.2.1.3. Friends, if you recall, I said that after the promulgation of these standards, if there is any change in law and there is any contradiction between, there is any inconsistency between the standard and the law, then the provisions of law shall prevail over the secretarial standard. In this case, the law was amended later on, hence this law will prevail and the particular part of the portion of the standard will not be applicable. However, now the standards are under revision, and the revised standards, this provision has been taken care of, and the revised standard do not provide for such noting of one level, but noting of managerial personnel one level below KMP. Through which mode sign minutes should be sent to the directors by the company? Any of, friends, those 5 modes: by hand, by courier, by speed post, by registered post, or by email. Can you please answer the question regarding ratification of resolution passed by circulation again? If a resolution has been passed by circulation, in the next board meeting, the normal practice is the companies are taking this item as to ratify the resolution passed by circulation or to confirm the resolution passed by circulation. My answer to this question is, in the next board meeting, this item, this particular resolution which has been passed by circulation shall not be taken for ratification or confirmation or approval. In the next board meeting, this resolution which has been passed by circulation shall be taken for the purpose of noting only. and the notice, your agenda may state like this, that to take note of the resolution passed by circulation on such and such date. Is it necessary to have a roll call in case of adjourned board meeting where the same is attended by director or VC? Whenever there is any meeting through video conferencing, whether original or adjourned meeting, a roll call has to be taken. Is it necessary for private limited companies also to send the signed minutes to each director? Answer is yes. The standards is applicable to all the companies. Even private limited companies are also required to send certified copy of the signed minutes within 15 days of the signing of the minutes. No other question?
No.
So friends, thank you very much. I hope you enjoyed the session. Still, if you have any other question, any other query on the standards, you are always welcome to write to me or to the institute. Again, I'll have try my level best to answer to your questions and queries. Thank you very much. Thank you.
On behalf of ICSI, I, Anamika Chaudhary, Deputy Director at ICSI, would like to thank Shri GP Madan for sharing his knowledge and expertise on the topic Board Meetings, Law, Practice and Procedure, Secretarial Standard 1. I'm sure that this webinar must have proved to be informative and beneficial to the viewers. I feel privileged and honored to present a memento on behalf of ICSI to Mr. GP Madan.
Oh, great. Thank you. Thank you, Anamika.
Thank you, sir.
So friends, cheer up. Thank you very much. Goodbye. Thank you.